Hello everyone, today I'm going to talk about the potential liabilities my creative house, Trestres, could encounter in the future. First of all, we are an agency that serves as a bridge between creative worlds, bringing to life campaigns and branding for musicians through the lens and unique styles of creative directors, filmmakers, designers, and so much more. Being so, some of the possible liabilities we could encounter in the future are related to copyright, breach of contract, and trademark. As one copyright case that serves as a reference of what may happen in a copyright infringement situation is the Liabilities versus Paramount Picture Corp., and it's about the renowned photographer Annie Leibovitz, who back in 1991 took a photograph of the actress Demi Moore while she was 8 months pregnant for Vanity Fair magazine. This picture gained a lot of attention and controversy, turning this image into a reference in pop culture. Later, in 1993, Paramount Pictures parodied the Moore photography to promote their new film, Naked Gun 33+1, but changing the face of the pregnant woman for the face of Leslie Nielsen. Annie Leibovitz, of course, claimed copyright infringement against Paramount for unauthorized use of her photograph in the teaser campaign. Paramount argued that the ad was a parody and that fell under fair use, which would negate infringement liability. The case resulted in the Southern District of New York initially ruling that Paramount's teaser campaign use of Annie Leibovitz's photo was fair use, which was upheld by the Second Circuit Court of Appeals. Despite the composition's resemblance, the court determined that Paramount use was permissible under the 4 fair use factors. The court considered that Paramount's parody and Leibovitz's licensing revenue market and licensing revenue from parodies was unlikely. It is clear from this case that even if a portion of the process can demonstrate that the use is fair, there is a significant risk to the entire process, and it's preferable to avoid this type of situations by avoiding parody or something similar. Another potential risk that a creative house may face is breach of contract, and one case that is related to this is the Florida versus Celsius Holdings, which is about how Florida sued Celsius Holdings, the makers of Celsius energy drinks, claiming breach of contract. He stated that Celsius had an endorsement deal with Florida and his production company, Strong Arm Productions, for 2014 to 2018, and that he was instrumental in Celsius brand development and expansion during the partnership. The dispute centered on the terms of the endorsement agreement, including Florida's promised ownership stake and the achievement of certain milestones. Celsius claimed that its success after the endorsement deal was due to other business decisions rather than Florida's involvement. The case ended with a jury in South Florida ruling in favor of Florida, determining that Celsius Holdings violated the contract with Florida by attempting to conceal money from him, resulting in an award of $82.6 million in damages for Florida. The third potential liability is trademark infringement. And one relevant case is Apple Inc. versus Amazon for the use of the term App Store for its Android marketplace, which violated Apple's trademark. Apple said that using a similar name could confuse consumers and undermine the originality of its brand. This happened back in 2011. Apple sued Amazon.com for trademark infringement and unfair competition. The main legal issue in this case was whether the term App Store could be protected as a trademark or if it had become a generic term describing a type of online marketplace for mobile applications. The lawsuit was ultimately settled out in court in 2013. The settlement terms were not made public, so the specifics of the agreement, as well as any financial or other obligations between the parties, remain unknown. However, Amazon continued to use the term Amazon App Store for its Android application marketplace after the settlement. Based on these previous court experiences, these are the best practices to keep in mind for my business. In terms of copyright, I must be absolutely certain that the material I intend to use, such as text, images, music, or videos, is either free of copyright or that I have obtained the necessary license or explicit permission to use it. Another way to reduce risk is to always create original content. This avoids infringement or someone else's copyright and saves money and time on obtaining permissions or getting in trouble. Finally, it is important to stay up to date on the latest copyright laws and legislations. When it comes to trademarks, the most important thing to remember is to do your research before using a name, logo, or brand identity, to ensure that it does not infringe an existing trademark. Check national trademark databases, search engines, and domain name registries to ensure that the desired mark is available. The safest way to go is always consult with an attorney and use a unique and original branding. Finally, the best practices for contract breach are centered on the importance of reading and understanding everything I sign, as it's critical to avoid misunderstanding or surprises, simply because I did not fully understand the terms and conditions. This potential liability is one that I believe is critical to my business, especially given that I will be working with so many parts, and we're all about delivering a service, so respecting both parties' commitments to fulfill all contract obligations within the time frames specified is critical.